Members, the committee is resumed. The House is in committee for consideration of the Taxation, Land Information and Offshore Persons Information Bill and the Gambling Amendment Bill No. 3 for... Just up to this point. Members, the question is that Clause 1 and 2, the Taxation, Land Information, Offshore Persons Information Bill, stand part.
Mr. Chair.
Grant Robertson.
Thank you very much, Mr. Chair. Yes, a lot of competition for that call. Mr. Chair, I want to focus particularly on Clause 2, the commencement date clause, and that towards the end of my contribution I'm going to table a document released to us under the Official Information Act by Land Information New Zealand. We need to go back in time a little, Mr. Chair. In fact, in this case, to the 11th of May 2015, when Land Information New Zealand was advising the Minister in charge of this bill, Louise Upston, about when this bill could actually come into force. And Cabinet was considering it. Interestingly, the context in this, Mr. Chair, of course, is that both this measure, the creation of a not register for purchasing of property, because the government doesn't want to call it a register and have successfully established it in such a way that it won't be an effective register, and the bright line test were both initiatives that were announced in the budget. It's quite clear they were rushed through because the government didn't have anything in the housing space that it wanted to do. And so Land Information New Zealand found themselves advising their minister about prospective commencement dates for this legislation. And they advised the minister in a note dated the 11th of May 2015, which I will put in front of the House shortly, that they didn't see any reason why they couldn't implement it either by 1 July or indeed from budget night, which seemed quite ambitious. They put some pros and cons in the note. They said that if they got it in place by the 1st of July, that would mean earlier compliance with the government's policy, and they would, quote, be seen to be moving quickly, which is clearly the main purpose of this legislation, has been seen to do things. The cons to the legislation coming into effect on the 1st of July were that there would be a very short time to consult on the changes with conveyancers and develop guidelines. And this is where things get interesting. The other con was that conveyancers would need to manually record information via a form until Land Online was in a position to be able to manage this. Now that's a bit of a worry. A significant change to the process around registering land purchases, and the website, Land Online, is not ready. So that's the information Lynn's provided. They said by the 1st of September they were pretty confident that they would be able to get it into position, but they were a bit worried about that. Lynn's also noted, Mr. Chair, in the same thing, that if they were to try and get this bill to commence on the 1st of September, it, quote, may lead to a rush of transactions by persons wanting to avoid the IRD number requirements and avoid tax. I'd be interested to know from the government side of the House whether or not that actually occurred, but I'm not aware that it did, but obviously that was one of the risks. To get the legislation in place by October the 1st, which is obviously what we are now faced with in the commencement clause of this bill, there was a suggestion that the government was going to need to use urgency and to get the regulations in place by this, September the 14th. The way, of course, that the government got around all of this was by truncating the Select Committee consideration of the bill. So they do come to us today with a Clause 2 that has the 1st of October as the date by which this bill will commence. The consultation with stakeholders and the process that was gone through has been rushed. And we've already seen in this House the fact, in the debate earlier today, Mr. Chair, that actually it's confused. We've got the commentary in the bill from government members of the Select Committee saying they know it's confusing, they don't know exactly how it's going to be implemented, and that is the effect of rushing legislation through, of not having a proper process. But Mr. Chair, the kicker in the advice from Land Information New Zealand is this, that they will have to use manual or paper-based systems to record transactions from October the 1st until the computer system is ready in December. So when this comes into force, from the 1st of October, commencing as it does under Clause 2, paper-based transactions.
Carbon paper?
Well, possibly. The Gestetner will be working overtime down at Land Information New Zealand, Mr Chair, because unbelievably, the government has put itself in a position where a fundamental change that they're making, you know, they've stood up here and told us, Mr Chair,
I call Grant Robinson.
thank you, Mr Chair. They stood up here today and told us, you know, this was going to give clearer information, objective tests, etc., etc. And they, LINZ, have been telling their minister that a manual and paper-based system will be in place. I mean, is this the 1960s? What's going on here? What's the risk here, Mr Chair, that actually lots of information will get lost in the system, that actually we won't be able to start creating the database that the government tells us they will, because for 3 months, it'll all be done in pen and paper. Maybe it'll be done on slate. I don't know how far back Land Information New Zealand is going to have to go to find a technology that's actually ready to do this. Now, I have to note, Mr Chair, that the information I'm working off, which I said I'm going to table at the end of my call, could be out of date. It is possible. This was a memo from May released into us under the Official Information Act. But that, to me, is an absolute debacle. This bill is being held together by string and sticky tape. It's absolutely poorly thought out. It doesn't do the things it was meant to do. On one hand, it makes things more complicated when they don't need to be, in terms of forcing people to have a bank account and an IRD number when they really only need an IRD number. But it fails because we exempt, or the government exempts under this legislation, the main home from having to be part of the register, which creates an enormous loophole when there is no additional compliance cost. This is an utterly confused piece of legislation, Mr Chair. Most parties, in fact, I think all parties in this House, support the principle of the bill, support the idea that there is a register, and we are voting for it because it is a tentative, incremental, little, tiny footstep in the right direction of giving New Zealanders the information.
But it's good.
It's okay, Mr Finlayson. I think good would be pushing it a little far. Great would be completely out of the question and hyperbolic. But it's okay. But what we are facing, looking at clauses 1 and 2, is a bill commencing on the 1st of October. That was the grand date put in place by the government. And the agency charged with collecting the data, Land Information New Zealand, through their system Land Online, are advising their minister that a manual, paper-based system is required to make this work until December of this year. Goodness only knows how the government thinks that this is a good way to make law. It's not. It's a shambles, it's a debacle, it's half-hearted, it's full of holes. And how ridiculous is it when you have support right around the House for the principles of legislation like this, to then put up such a flawed piece of law? If we'd had longer at the Select Committee, if there'd been more time to consult, if the government had actually wanted to do this and get a meaningful outcome, as opposed to the window dressing that this clearly is. And we go back to the budget when this document was put out, Mr Chair, and we see that it was rushed. When the budget papers were released in July, we discovered that none of the housing initiatives that the government is putting up that are buttressed by this legislation and the Bright Line test had any work done on them at all last year in the normal course of the budget process. They were stuck in early in 2015 when the government was on the back foot on housing. It's still on the back foot on housing. But when the government was on the back foot on housing, it had nothing in the budget to show, so it thought it would come up with something. Deal with the concern New Zealanders have that they don't have the information that they need to be able to understand who is buying and selling houses in the New Zealand housing market, and equally that people who are speculating, the intention test is completely not working, and so the Bright Line test has been brought in. When When we come to debate the bright line test in this House, we will similarly discover the perils and dangers of rushing legislation through with inadequate consultation. So, Mr Chair, I believe that Clause 1 and Clause 2 of this bill highlight, perhaps more than almost any other clause, just how poorly thought out this process has been. The fact that Land Information New Zealand told the government they could get the system up and running, but it would have to be paper-based from the 1st of October until December is a complete farce. Point of order, Mr Speaker. Mr Chair.
Point of order. Grant Robertson.
Mr Chair, I seek leave of the House to table an aide-memoire from Land Information New Zealand to the Honourable Louise Upston, Minister for Land Information, dated 11 May 2015.
Leave is put for that purpose. Is there any objection? There appears to be none.
Mr Chair.
I call Stuart Nash.
Thank you very much, Mr